Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we cover Urias-Orellana versus Bondi, a unanimous 9-0 decision handed down on March 4th, 2026. Justice Jackson wrote for the entire court. No concurrences, no dissents, every single justice agreed. The Supreme Court ruled that federal appeals courts must apply a highly deferential standard called substantial evidence review when they second-guess immigration agency decisions about whether someone suffered persecution severe enough to qualify for asylum.
In plain terms, this decision makes it significantly harder for asylum seekers to win in federal court after losing before immigration judges. And it resolves a decades-long disagreement among the nation's circuit courts about the rules of the game.
Big stakes, important ruling. Let's get into it.
But first, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, let's proceed.
Picture this. It's 2016. Douglas Humberto Urias-Orellana lives in El Salvador. He learns that a hitman, in El Salvador they call him a sicario, targeted his family.
And not just vague threats. This hitman shot 2 of Urias-Orellana's half-brothers, then vowed to kill every member of the family. Every single one.
So Urias-Orellana does what any reasonable person would do. He runs. Packs up, moves his family to a different town. Fresh start.
Except the threats followed. After every relocation, men showed up, demanded money, told him they'd leave him like his brothers if he refused to pay.
That's an explicit death threat, referencing the brothers who already got shot.
And it got worse. When Urias-Orellana briefly returned to his hometown, one of these men physically assaulted him.
So he moved again and again. 4 total relocations across El Salvador between 2016 and 2021.
The 4th move came in 2021. Shortly after settling into yet another new town, Urias-Orellana heard that men went around asking locals about any newcomers who recently arrived.
He connected the dots immediately. These men were looking for him. Again.
At that point, Urias-Orellana, his wife, Saira Ileana Gamez Mejia, and their minor child, identified in court documents as GEUG, left El Salvador entirely. They crossed into the United States without authorization in 2021.
When the U.S. government found them, it served the family with notices to appear in immigration court in Boston for removal proceedings.
Urias-Orellana didn't deny entering without authorization. He conceded it, but he said, "I qualify for asylum. My family qualifies for asylum. Send us back, and this hitman finishes what he started."
He took the stand as the sole witness at the hearing. The immigration judge, called an IJ, listened to the whole account and found him completely credible, believed every word.
But then delivered a gut-punch ruling. Credible or not, those facts don't legally rise to the level of persecution under the immigration statute.
Ouch!
Ouch is right.
So the IJ denied asylum for the whole family. The wife's and child's claims counted as derivative, meaning they rode entirely on Urias-Orellana's claim. All 3 ordered removed.
They appealed to the Board of Immigration Appeals, the BIA, the Administrative Review Board for Immigration Decisions. The BIA affirmed, said the same thing, the harm didn't hit the legal threshold for persecution.
So then they went to federal court, the U.S. Court of Appeals for the First Circuit.
And the First Circuit affirmed too. But here's the critical part. The First Circuit said its hands were tied. It applied what's called the substantial evidence standard, meaning it could only reverse the agency if the evidence so overwhelmingly pointed toward persecution that no reasonable decision-maker could disagree. Under that demanding test, the agency's call survived.
And that standard, substantial evidence review, turns out to be the entire ballgame.
Because not every federal circuit court played by those same rules. Some circuits applied that deferential standard to the whole persecution analysis. Others said The legal application piece gets de novo review. That's Latin for fresh, independent judicial scrutiny. No deference to the agency at all on the legal question.
So, which asylum seeker won or lost in federal court could depend entirely on which circuit they filed in. Same facts, different state, different outcome.
Exactly the kind of conflict that gets the Supreme Court's attention. The court agreed to take the case in 2025, heard argument on December 1st, 2025, and decided on March 4th, 2026.
Okay, the legal question sounds technical, but we'll break it down. When a federal court reviews an immigration agency's determination about whether someone suffered persecution, do the courts defer to the agency or take a completely fresh look on their own?
And to unpack that, we need the key statutory provision at the center of everything. It's from the Immigration and Nationality Act, the INA, at section 1252B, 4B. Here's what it says. The administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary.
In normal person language, the agency wins, unless the evidence so clearly points the other way that no reasonable person could side with the agency.
That's the substantial evidence standard. Think of it like a challenge flag in football. The call on the field, the agency's decision, stands unless the replay shows it so clearly wrong that no reasonable official could let it stand. You need overwhelming evidence to overturn it.
And that's quite deferential to the agency.
Now, the family's lawyers argued something clever. That language covers findings of fact. But whether someone suffered persecution isn't purely a finding of fact. It also involves applying the law to those facts. So maybe that part gets fresh judicial review.
It's actually a pretty intuitive argument. Facts get deference. Legal questions get independent scrutiny from judges. That's generally how courts operate, but that didn't work here because of a 30-plus-year-old precedent.
Bingo. Justice Jackson grounded the whole opinion in a 1992 case, INS versus Urias-Zacharias.
What did that case involve?
The exact same scenario. An asylum seeker lost before the immigration judge and BIA. A federal appeals court reversed. The Supreme Court stepped in and flipped that reversal.
And what did the Supreme Court say in 1992?
To get a federal court to reverse an agency's persecution determination, the asylum applicant must show that the evidence he presented was so compelling that no reasonable fact finder could fail to find the requisite fear of persecution. The court applied that deferential standard to the entire persecution inquiry, not just raw facts, but also whether those facts legally constituted persecution.
So the Supreme Court already answered this question in 1992?
According to Justice Jackson, yes. The lower courts just forgot.
Okay, but wait. Congress amended the immigration statute after 1992. Doesn't that change things?
That's exactly what the family's lawyers argued. Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act, called IIRIRA, in 1996, and that's when Section 1252B4B got added to the statute.
So Congress superseded the 1992 case with new language?
Jackson says, look at the actual words Congress chose. Compare the 1992 Urias-Zacharias standard, so compelling that no reasonable fact finder could fail to find the requisite fear, to the new statute, conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary.
Those sentences say the same thing in different words.
That's exactly Jackson's point. It's like a student copying the teacher's answer and turning it in as original work. Congress took the court's own standard and rewrote it almost verbatim into the statute.
So Congress didn't replace Urias-Zacharias. Congress codified it, locked it in.
And the court draws on a principle from a 2023 case called Bartenwerfer versus Buckley. When Congress enacts statutes, it knows this court's existing precedents. By mirroring Urias-Zacharias almost word for word, Congress signaled it intended to preserve that standard, not overturn it.
And then Jackson zooms out and looks at IIRIRA's entire structure.
Right. The whole statute narrowed federal court review of immigration decisions. IIRIRA stripped jurisdiction over certain removal orders entirely, made other agency determinations conclusive, put more gates between asylum seekers and federal judges, reading one provision of IIRIRA to expand judicial review runs against everything else the statute does.
Jackson called it anomalous.
Then the family raised two more recent cases, Wilkinson versus Garland from 2024 and Guerrero-Lasprilla versus Barr from 2020. Both treated mixed questions, blended fact and law questions, as questions of law for certain purposes.
So did those cases require fresh review here?
Jackson distinguished them cleanly. Those cases addressed a different provision, Section 1252A, which determines whether courts can hear a removal case at all. Think of it as the doorway into federal court.
The doorway question and the scope of review question are entirely separate.
Exactly. Whether a question qualifies as a legal question for getting through the door says nothing about how much deference the court applies once it steps inside. Different provision, different purpose, different answer.
And here's the thing about asylum determinations specifically. They turn almost entirely on facts. What actually happened to this person back home? Did threats follow them when they moved? The IJ makes those calls. And even where the IJ accepts every word of the testimony as true, like here, the IJ still judged whether that testimony rang credible in the first place.
Right. It's like accepting an eyewitness's account of a car accident as completely truthful, but then letting a second judge second guess whether the driver the witness identified actually caused the crash. You already trusted everything the witness said. Second guessing the conclusion drawn from those very facts would be strange.
And that's why Jackson called it anomalous to defer on the facts, but then hand the legal application back to federal judges for a fresh look.
Anomalous. That word keeps coming back.
Bottom line, 9-0, Justice Jackson writing for the entire court. Section 1252(b)(4)(b) of the INA requires federal appeals courts to review the entirety of an immigration agency's persecution determination, both the underlying facts and the application of the legal standard to those facts, under the deferential substantial evidence standard. The First Circuit applied the right standard, affirmed,
And the Urias-Orellana family loses.
no concurrences, no dissents. Every justice signed on without a separate word.
And that tells you something. 9-0 on an immigration case, a fiercely contested area of law, signals the court viewed this question as settled. Jackson built the opinion on a precedent the court itself wrote in 1992, showed Congress essentially ratified it 4 years later, and demonstrated the whole statute pointed the same direction. Hard to pick a fight with your own prior reasoning.
Time for our What This Actually Means segment.
So what actually changes after this decision?
For families sitting in immigration court right now, people in exactly the same position as the Urias-Orellanas, the path to winning in federal court just got significantly steeper. You can still appeal, but the federal judge now asks one question. Could any reasonable person have agreed with the immigration agency? If yes, the agency wins.
And judges in circuits that previously applied fresh, independent review to the legal side of asylum determinations, the 2nd, 3rd, 5th, 8th, 9th, and 11th circuits, among others, must now shift to deferential review, uniformly, nationwide.
For immigration lawyers, this reshapes strategy entirely. Legal arguments targeting how the agency applied the persecution standard to accepted facts, arguments that once opened the door to independent judicial scrutiny, carry far less weight going forward.
For employers, nonprofits, law schools, resettlement organizations, anyone who works with asylum seekers, this ruling signals that immigration courts and the BIA hold more power than ever, because federal court correction just got harder to obtain.
Here's the question the court left open, though. The Solicitor General, the government's top Supreme Court lawyer, conceded during oral argument that purely legal questions about the correct definition of persecution still get fresh review. Not the application of the standard to specific facts, but the definition itself.
Wait, so agencies can't just define persecution? however they want and claim deference?
That's the implication. But the court neither confirmed nor denied it. Jackson explicitly limited the ruling to the application of the standard to specific facts. What persecution legally means in the abstract, that question stays open.
Expect future cases to push exactly that line. Immigration lawyers already circled it.
And one more thing worth flagging. The court sidestepped arguments about Loper Bright versus Raimondo, the 2024 ruling that eliminated judicial deference to agency legal interpretations across large swaths of federal regulatory law.
Right, Loper Bright upended the rules in many contexts, but Jackson said it doesn't apply here because the INA itself commands deferential review. Congress wrote the deference standard directly into the statute. A congressional mandate overrides Loper Bright.
So if you thought Loper Bright might hand asylum seekers a path around deference, this court says no. Congress spoke too clearly.
After today, immigration agencies hold more power, federal courts hold less.
To sum things up, the Supreme Court locked in a deferential, nationwide standard for federal court review of asylum persecution determinations. Lose before the immigration judge and the BIA, and winning in federal court now requires showing the evidence so overwhelmingly favored your claim that no reasonable person could rule against you.
That's a hard bar. And a family who fled a hitman, relocated 4 times, and watched their half-brothers get shot still lost because the legal standard for persecution demanded more than what their evidence showed.
The human story doesn't disappear just because the legal ruling runs against you.
It really doesn't.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
You already proved you meet the threshold. You stayed to the end. Now subscribe and leave a 5-star review. No reasonable listener would conclude otherwise.
The court just unanimously agreed. Talk to you soon.